Well, hello there. It is great to see you, and welcome back to another installment of Closing Arguments. I'm your host and moderator, Ryan Ruff. Boy, is it great to have you back with us. We've got the star of the show, Mr. John Razumich, or Jack Razumich, as those close to him know him by, joining us momentarily for another criminal law-related discussion. But you knew that already because you are a frequent listener and viewer of this show. But hey, look, I want to take one quick moment to acknowledge just those that are jumping in and joining us. They're coming in now here on the Facebook live stream. First and foremost, thanks for joining us live. We appreciate you being here. One of those great perks of being a live viewer or live listener on this show is that comment box right below. So feel free to drop a comment or a question below as we're going through our conversations, whether it be this episode or future live streams. We always love to hear maybe where you're watching us from, or any questions that you might have on the topic at hand. We'd love to dive in and explore your question because, hey, while Jack and I always have a great conversation on here, sometimes some of our best conversations come from you guys, our audience. So please, if you are joining us on the Facebook live stream, drop a question or a comment below. We'd appreciate you. But for the other group, those that might be jumping in after the fact on YouTube or a podcasting platform, all the same, we do appreciate you being here and joining us for another discussion today. We would love to have you back with us, maybe on a future Facebook live stream. And if you need any details on those as to when they might be coming out, you can always head over to the Razumich and Associates Facebook page. Plenty of information on the show you can find over there. But anyway, hey, look, we had a great conversation teed up for you today. We'll be bringing Jack on in just a moment. Today's theme, and Jack and I were just chatting before the show here, might end up actually even being a two-part episode, depending on how much we get into today. There's a lot to unpack in this great conversation today. What are we diving into today? Well, we're getting into the forgotten legal landmarks, specifically United States versus Shipp. Now, when Jack and I were planning for this episode, he had mentioned this particular court case, and I was scratching my head. Probably like many of you out there, what is this case? Why? I feel like I should know something about it. Well, that's okay. Luckily, we've got Jack today to bring on and dive into what is really a prominent case, but yet forgotten at the same time. Why? Luckily, we've got Jack to shed some light on that, provide that background, really get into the nitty gritty of this case, just why it's so important here today. So that being said, let's go ahead and bring out Jack. Let's get this conversation rocking and rolling. Jack, great to see you. Welcome aboard. How you doing today?
I'm surviving. We all survived 2021, first show of 2022. Still writing. I'm actually writing December on my correspondence. I'm not writing 2021. I've got the 2022. I'm just still in December mode for some reason. So
it's funny you say that. I am very so. There have been a few times where I've marked 21 on some things, like a check you got to cancel.
Right.
Those kind of things. Well, either way, glad you're here with us, Jack. I'm excited to kick things off here in 22. We've got a great conversation on tap for everybody today in United States versus Shipp. But as you had pitched this to me for a topic that we were going to talk about, I knew that there was going to be some research that needed to be done on my end because I didn't know much about this case at all. But I think, in the research that I've done, as well as just talking with you about this particular case, the devil is in the details, particularly those details being the background, really, of this case. Take us back to the beginning. Talk to me about really where this all stems from, is this idea of the original jurisdiction of the Supreme Court. I think that's where it all really begins here with the United States versus Shipp. Take us back. Talk to us about this idea of the original jurisdiction.
Sure, absolutely. And for the benefit of anyone that's listening, normally we would not do this. This is a legal-based podcast, a legal-based show. History is not always very nice. I will give anyone who is listening either live or listening after the fact, I will give you a little bit of a content warning. This particular case, the history of this case that we are dealing with today, does involve, for lack of, there's really no polite way of phrasing it, there is a lynching that's involved. And I do know that rather than ambush anyone who's listening to this with that information there at the end, we're going to be very upfront about it. We will treat everything as respectfully as we normally would, but in the interest of full disclosure, it is probably one of the shows that we've done to date. It definitely does have that sensitive aspect to it. The case itself, United States versus Shipp, is a fascinating historical artifact. It is what makes it most noticeable. It is the only original jurisdiction criminal case that was argued before the Supreme Court of the United States. And what that means is courts have two types of jurisdiction. Jurisdiction is the ability to hear a case. There are two types of primary jurisdiction. You will have what's referred to as original jurisdiction, which is the case can be filed directly into that court as an original action. The other type of jurisdiction, which is what appellate courts traditionally have, is what's referred to as appellate jurisdiction. Appellate jurisdiction means that another case operated as the trial court, and that case made a decision, and then that case went up through the appellate system, and the courts that made those appellate decisions are exercising what's referred to as appellate jurisdiction. Supreme Courts, both of the several states and of the United States, Supreme Courts do have original jurisdiction over certain matters. And with regards to the Supreme Court of the United States, the original jurisdiction of the Supreme Court of the United States is spelled out in Article 3, Section 2 of the United States Constitution. It states that the Supreme Court has original jurisdiction over cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party. And if you look at a lot of the really, really early Supreme Court cases, most of them are things like, Massachusetts versus Delaware, or Indiana versus Kentucky, or Ohio versus everybody, because there's an awful lot of litigation over who controls the Ohio River. But those are cases that are filed originally directly with the Supreme Court. Most cases reach the Supreme Court through the appellate jurisdiction. One of the earlier episodes that we did, we talked about what happens after a conviction. Those appeals are what are referred to as appellate jurisdiction. So what makes United States versus Shipp so unique is out of the, 240-ish years of existence that the Supreme Court has been a thing. This was the only original jurisdiction criminal case that was filed directly into the Supreme Court. And it's got all the traditional trappings of an original jurisdiction criminal case. There are defendants, there are attorneys, there are 16 people standing in front of 9 justices pleading not guilty. It's a fascinating history. And there is precedential value to it. Even though this case was decided in 1909, there are aspects of this case that are still important the way that we approach certain types of criminal cases today. So it does have importance. It does have continuing value, but it really is. It's very forgotten. It's a small blip in the history of the court's jurisdiction. And there's a lot of criminal attorneys who don't even know about this case, which is absolutely fascinating. But
right.
It was one of those things that we were able to kind of we kind of unearthed it when we were doing research and going over topics, and it seemed like a great concept to share with everybody else.
Yeah, isn't it fascinating, Jack? Just thinking that a case with such history behind it is still leaving, a footprint today, and then to take that concept and couple it with the fact that it is kind of a forgotten case is just equally as fascinating. So let's get into the details really of this case. Talk to us about the assault of Nevada Taylor. That's really where things begin. Walk us through it.
Right. Like I said, the case that we're talking about, the official designation, the decision by the Supreme Court was issued in 1909. The case itself actually starts in 1906. More specifically, January 23rd in 1906. So we're recording this on January 18 of 2022. So almost 112-ish years ago, I think. My math is terrible on that, but we're almost to the date of this case, the genesis of this case. So what happened is in Chattanooga, Tennessee, on January 23rd in 1906, a young lady who was a bookkeeper at a grocery store by the name of Nevada Taylor Nevada Taylor was a 21-year-old white woman who was living there in Chattanooga. She was on her way home from work at approximately 6 p.m. She took the electric trolley towards the home that she was sharing with her father at the time, which is at the base of Lookout Mountain, if you're familiar with Chattanooga or the Tennessee geography, generally speaking. And this is, I suppose, this is our second opportunity to kind of provide a trigger warning to anyone who's listening to us, or content warning to anyone who's listening to us. It's about to get really dark really fast right off the cuff on this one, because what happens is she gets off of the trolley maybe about 6:30, 6:40ish, something like that. She gets off of the trolley, and very quickly after getting off the trolley, she's basically ambushed from behind. She hears footsteps running up behind her, and before she can turn to do anything about it, um, there's a leather belt or a strap or something goes around her throat and starts choking her. And according to her reports to the police, she says that a man's voice whispered in her ear, "If you scream, I will kill you." And she passed out from lack of oxygen. She was basically being strangled, so she passes out. And about 20 minutes after that, she wakes up. She knows that she has been in, she knows that she's been assaulted. So she runs the 100 or so yards to her house where her father is, and they use a newly installed telephone, because again, remember, that's how old this case is. Telephones were uncommon, but they had one of the few telephones that was in the area, and her father used the telephone to call Sheriff Joseph Shipp to report that his daughter had been assaulted. And that's really what started this process right off the cuff. Is you have an assault of a young woman by an unknown entity, and things kind of continue to go downhill from there. Is perhaps the easiest way of phrasing that.
So we have this unidentified individual that's come up from behind Nevada Taylor, more or less strangled her.
Right.
We have nothing else to go on here in this case yet.
Right.
Take us through the next chapter, if you will, Jack. This idea of really where the identification and then, of course, the arrest of Ed Johnson comes into play.
Right. Like Ryan pointed out a moment ago, there's nothing else to go on. This is pre-forensics. This is pre-CSI, fingerprinting as a concept for identification. This is all relatively new stuff. Yeah. So, like most investigations, this investigation was very heavily put together on the concept of if you saw something, say something. They have to rely a lot on public support. Public involvement to kind of, again, just address this is what I saw, or this person is suspicious. So what ends up happening is, again, it's 1906. It's a small town. Chattanooga was not that big back at the turn of the 20th century. It's still not a huge metro area. It's definitely bigger than it was back then. But this is effectively the crime of the century for Tennessee. And the next day, what ends up happening is the local press coverage starts calling the attack on Miss Taylor the most fiendish crime in the history of Chattanooga, which is probably correct, to be perfectly honest. And the press is the entity that really started inflaming the tensions on this. Because, again, remember, Miss Taylor was attacked from behind. What she knew is that she heard footsteps running up towards her. She feels the leather strap around her neck, and she passes out because she's been strangled. This is what she knows. What the press has added into it is the press has decided that this crime was committed by, and this is a direct quote from the paper, the crime was committed by a Negro brute. And the press's justification for that is kind of like your no true Scotsman fallacy. There is no decent white person who would have committed this crime. Clearly, it must be a Negro brute, and that's what they ran with. And once the press got its teeth into the idea that the perpetrator was a Black American there in Tennessee, there was no further investigation. They just started looking in that direction.
Mhm.
And it got worse because on January 25th, 2 days after the attack, Sheriff Shipp, uh, Judge Samuel McReynolds, who was the county judge for Chattanooga, and the governor of Tennessee, William Cox, the Tennessee governor at the time, offered a reward of $375 for anyone who could identify the attacker. Now, that's $375 in 1909 money. That's over a $9,000 reward. It's probably closer to $10,000 given the rate of inflation right now. But it's about a $9,000 to $10,000 cash reward for anyone who could identify the attacker. So what happens next is an itinerant. I don't know if you would call him a bum or the town drunk or just someone who is habitually unemployed,
Mhm.
by the name of Will Hickson showed up at the sheriff's office, and he told the sheriff that he saw a Black man by the name of Ed Johnson carrying a leather strap near the scene of the crime about the time that it took place. So the identification is made by an unreliable, habitual, unemployed drunk. There's where Mr. Johnson's troubles began, because at that point in time, all the attention focuses on Mr. Johnson, who really should be the central focus of the story at the end of the day. The case is called United States versus Shipp. Anyone who's listening probably picked up that Shipp is the name of the sheriff. We'll explain how he ended up getting attached to it. But Ed Johnson is really the important part of this story. Um,
Mhm.
Ed Johnson was a 19-year-old kid, for lack of a better way of describing it, who he dropped out of school in fourth grade, which was pretty common, unfortunately, for not only Black people but also all sorts of people. It's not exactly a very well off area. So dropping out of school at that age, that was a very sadly common thing. Um, he couldn't read, he couldn't write, and most importantly, he had no criminal record. That's again something
Mm.
that I want to be very clear about. Even though he drops out of school at basically 10 years of age, over a 9-year period in the Deep South, he doesn't have a criminal record. He's never come across the law in any way, shape, or form. There's nothing that he's ever done wrong. There's nothing he's ever been accused of until right.
Mhm. Yeah.
And Ed's during the day he does odd carpentry jobs for local churches. He tended pool tables at a bar called the Last Chance Saloon, which is right there it was, I don't think it's not there anymore. It's right there on the
Sure.
border of Tennessee and Chattanooga. So he's just a normal guy.
Yeah, it doesn't have the resume, so
Yeah.
to speak. That's really interesting to hear that. All right, so here we are. We've got Ed Johnson enters scene as primary suspect based on the work or the word rather of what seems to be the town drunk. Uh, the case is called United States versus Ship.
Mhm.
Why is Sheriff John Shipp name on that case? Talk to me about his role in all of this and where it starts shifting towards Ship.
Well, it starts shifting towards Ship much later in the story.
Mhm.
I don't want to get too far ahead of ourselves because there's
Yeah,
a
let's
lot
not
that
get too
still
far
needs to
ahead.
be discussed with Ed Johnson. But
Sure.
the reason that it's Ship whose name is on the case is Sheriff Shipp is one of the defendants in this case. He is one of the people that is charged with a criminal offense directly before the Supreme Court of the United States as a result of what happens in this case.
Mm.
Um, Ed Johnson, unfortunately, will not live to see the end of this case. I guess that's our advanced spoiler on getting ahead of it. But because he's not
Yeah.
there, and Sheriff Shipp has something to do with him not being there,
Mm.
that's why his name is attached to it. Criminal cases As a general practice, criminal cases are always brought in the name of the prosecuting agency. In Indiana, criminal prosecutions are brought in the name of the state of Indiana. In California, they're brought in the name of the people of California. In the United States federal system, of course, it's brought in the name of the United States versus whomever the defendant happens to be. Getting back to Mr. Johnson, which is really, again, as I said, this probably the most tragic thing about this story at the end of the day is, again, that is forgotten because of Mr. Johnson as much as anything. He deserves to be remembered on this. He deserves to have his what he went through memorialized a lot better than it has been. And for right now, we'll at least kind of keep that focus on him to kind of give everybody an idea as to what was going on. So based off of the strength of what Will Hickson, his identification, based off this completely unreliable identification, Sheriff Shipp arrests Johnson. And if you'll recall one of our earlier episodes when we talked about the Miranda advisements, we're like 60 years almost before Miranda's a thing. So, Mr. Johnson, Mr. Johnson is taken to the police station. He is interrogated nonstop for 3 hours. He's not made aware of any potential constitutional rights that he has. He doesn't know that he gets the presumption of innocence, that he has the ability to ask that a lawyer help him, any of those things. So he's just constantly interrogated nonstop for 3 hours. Despite that, though, he manages to maintain his innocence for the entire 3-hour ordeal. He never breaks once. He very much just sticks with the concept that I didn't do this. He is very adamant that he is an innocent man. He provides an alibi. He claims that he was at the Last Chance Saloon all night, and he provided names for a dozen different men who could substantiate that alibi. So this isn't even a situation that he's coming up with something out of whole cloth. He worked at the Last Chance Saloon. He said that he was there the night of the attack, and he gives the name of a dozen different patrons who theoretically in his mind can say, yes, we saw Ed that night. He was working. Whether, it's unclear from the record how much Sheriff Shipp actually bothered to investigate that. The record's a little bit unclear as to what Sheriff Shipp did do with regards to just verifying whether the alibi is correct or not. The one thing that Sheriff Shipp did do that was actually decent in this entire story is knowing that the press has basically inflamed all of the passions of the town by coming up out of whole cloth that a black man was responsible for this attack. The sheriff has now arrested a black man. A white man has pointed the finger at this particular black man who's been arrested. Sheriff Shipp did one of the only good things that he did in this case. Believing that Ed's life was going to be in danger if he was held in Chattanooga, the sheriff and Judge McReynolds secretly moved Mr. Johnson to a jail in Nashville while he was awaiting trial. So they did move him, which turned out to be a great decision. It probably saved Ed Johnson's life at that time, because over the next 2 days, there were 3 separate raids on the Hamilton County Jail in Chattanooga by about 100 townspeople. Wow. All with the attempt of trying to get into the jail to get Ed Johnson, with the concept of lynching him before he even made it to trial.
And this is and Jack, this is a town that's been fueled by really the press.
Absolutely.
That lynched, that they really just locked their jaw, like you had said earlier, on that idea of a Negro brew. It's been fed by the press for so long. It's now reached that boiling point. So it is interesting to hear you say that Sheriff John Shipp had made that what was a really good call in that moment. Man, so sorry, continue. I just wanted to say, boy, is that interesting just to hear that Shipp made such a good call despite not knowing that the town might boil over like it did. Maybe he did, but either
he
way.
had to have suspected it. Again, remember where we are. We're in the
Sure, sure.
South. Um, and that's the fascinating thing with the history of some of this stuff is, again, remember, this is 1906.
Mhm.
There are people alive who fought in the Civil War at this time. You know, the timeline is not so expansive
Mhm.
that this isn't a recent memory. Reconstruction has only been over for about 20 years. Plessy versus Ferguson, which was the case that legally enshrined segregation, that case is maybe 10 years old. So the idea that we might have a lynching if we keep Ed Johnson here in Chattanooga, you know, you probably didn't need a crystal ball for that.
Yeah.
And like I said, it was literally the only humane thing that Sheriff Shipp did during this case. I want to be very clear
Mhm.
about that. He is not a good person. This was about, you know, even bad people can make the good decision occasionally. And at this point in time, he is at least taking Ed Johnson's safety seriously. And they do move him to
Mhm.
Nashville while they're waiting for the trial, which is a protection on that.
Sure.
So
Sure.
the next major thing that happens with this case, you know, and again, this goes back to one of our earlier shows about the concept of how fast and speedy trials work and how things used to move very quickly.
Mhm.
Remember, Nevada Taylor's attack is on January 23rd. Ed Johnson is arrested 2 days later on January 25th.
Wow.
Ed Johnson is now brought in front of Judge McReynolds on January 28th for his arraignment. So we have an investigation that has lasted 5 whole days on this. That's all
Wow.
the investigation that went into this. We've got 5 days from the attack to
Mm.
the arraignment. So Ed Johnson is brought back before Judge McReynolds in Tennessee, in Chattanooga. And Judge McReynolds announces that he's appointing 2 lawyers to represent Mr. Johnson. Normally, that sounds great. You know, not only are you getting 1 lawyer, you're getting 2, and he's not being made to pay for it. You know, because again, this is pre Miranda. This is pre Gideon versus Wainwright. That's another case that we'll talk about at some point in time in the future. But that's the case that guarantees representation if you can't afford it. So in the Deep South, in Reconstruction era Chattanooga, Tennessee, Judge McReynolds is appointing 2 defense attorneys to represent a black man in an alleged crime against a white woman. Sounds great, right? The problem is neither of those lawyers had ever handled a criminal case in their entire career. So
Oh my goodness.
two attorneys who have never handled a criminal case are suddenly dealing with what's literally the crime of the century for Chattanooga, Tennessee. You know, so that's kind of, again, stacking the deck against you. Fortunately, there was a third attorney by the name of Lewis Shepard, who was a former judge and one of the most respected lawyers in all of Tennessee, stepped forward to volunteer his services at no cost. Because, you know, even in stories like this, there are always good people who are at least going to stand up and say, wait, this is wrong. Let me fix this. So because Mr. Shepard is the most experienced of the 3, and because he's actually handled criminal cases, he quickly becomes the lead attorney on this case.
Mhm.
And he shows up on January 29th to offer his services. And on that day, Judge McReynolds meets all 3 attorneys, and he advises them that Ed Johnson's trial is going to be in 10 days. And part of that is, again, you know, we've just had 2 nights of attempted storm. Well, I guess they really did technically storm the jail. They didn't get into the jail, but you've got 2 nights of people storming the jail, trying to do a lynching. Judge McReynolds' concept is, again, although looking at it from completely the wrong direction, his concept is like, this town is not going to be safe if we don't get this done. So they set the trial in 10 days' time, which Mr. Shepard very correctly argues that it would be impossible to prepare an adequate defense in 10 days. Again, think back to one of our earlier our might have even been our first episode, that whole concept of how long it takes to prepare a case to
Mhm.
properly handle
Yeah.
that. Imagine being a defendant and having your attorney told by the judge, you get 10 days. 10
Mm.
days and it's go time.
Yeah.
Um,
That's
so again, that's horrible. That's what we're
fast
dealing
and
with.
speedy, some might say.
Fast and yeah, it's incredibly
Yeesh.
fast and speedy, not
Yeah.
particularly fair and equitable, and we'll get to that portion of it later.
Mhm.
But definitely moving it quickly. And again, to his credit, Mr. Shepard is doing everything he can in his ability to extend this process, to build a defense. Judge McReynolds, according to affidavits that were signed by Mr. Shepard during the federal portion of this case, according to Mr. Shepard, Judge Reynolds at one point in time told the attorney specifically, don't file a motion to continue the trial because I won't grant it and it's only going to make me angry. As you can imagine, this is not really what you want to hear from a judge. You don't want to hear a judge tell your defense attorneys, don't file this motion because not only am I not granting it, I will hold it against you. That's effectively what he's saying. So the next thing that Mr. Shepard does, again, just trying to make sure that he's doing everything that he can to properly protect Ed Johnson, asks to move the trial anywhere else in the state of Tennessee. That's a procedural move that's referred to as a change of venue. A change of venue is an argument that's made by an attorney, usually a defense attorney, although sometimes prosecutors can make this argument as well. It's an argument that it is impossible to impanel a fair jury in this jurisdiction. We need to move it elsewhere. And Mr. Shepard is arguing um, quite persuasively that there have already been 2 lynching attempts in Chattanooga. There has been a sensationalized media attention on this case, and those 2 things combined, it would be impossible to find an impartial jury. Um, I don't think that I'm giving anything away by saying that Judge McReynolds was not interested in that either. The statement in Mr. Shepard's affidavit was that Judge McReynolds indicated, don't file a motion for change of venue. I'm not granting that either. So again, very much, we have justice theater is the easiest way of putting it right now. We have a
Mhm.
situation where, the judge has initially appointed 2 attorneys, which looks great, but those attorneys have never handled a criminal case.
Yeah.
Um, there's the concept of, for the safety of Mr. Johnson, we need to move this trial very quickly. So you get 10 days, no continuances, because I'm not granting them. And in
Mhm.
the face of 2 attempted lynchings already and sensationalized media coverage, which again, the media coverage is why they think a black man's responsible for this attack.
Political
So
theater was a really elegant way of putting that there, Jack. But yeah,
absolutely.
absolutely. Talk about the deck being stacked against you if you're Ed Johnson from the start.
Yep.
But
So yeah, February 26, 1906. That is the day that Ed Johnson's trial is actually set to take place. And that's where the story picks up from there, is with the trial itself.
right. So
Um,
to our audience, I mean, see what we meant by, this episode potentially being a two-parter. There's so much that does go into all of this before we can really get into the trial. Then of course it's aftermath and where the Supreme Court enters, there's just a lot to get into this. And then of course, real quick, Jack, before we really dive into Ed Johnson's trial and of course his later conviction, just a quick reminder to anybody that is with us live here on the Facebook live stream today, please leave us a comment or question below. We'll carve out some time to address that, at any point throughout the show. We appreciate you being here. But that being said, Jack, let's get into it. Talk me through what the trial of Ed Johnson looks like and how the deck continues to be stacked.
it looks like an absolute clown show, is perhaps the most polite way that I can phrase that. The jury itself, well, the trial itself, it starts on the morning of February 6, 1906. 10 days after Ed Johnson's arraignment. The jury is composed of 34 white men were summoned for jury duty that day. Back in 1906, blacks were very much being systemically excluded from juries. They were not allowed to sit on a jury. Women were also not allowed to sit on juries at this point in time. So the jury is made up, the jury veneer is called. You have 34 white men show up. 12 of them are selected for the jury. The state's first witness is Nevada Taylor. And remember, when the attack initially happened and the report was initially made to the sheriff, Miss Taylor told the sheriff and she told the law enforcement authorities that she didn't see her attacker. She couldn't identify her attacker. She had no idea what description of her attacker was. So that's her mindset on January 23rd. We're now on February 6th. So not even a full month later. After walking the jury through the events, the district attorney asks Miss Taylor if she can identify the man who assaulted her. And in a scene right out of an old courtroom drama, according to the trial transcript, she points her finger directly at Ed Johnson and says, "I believe that he is the man." So that's the strength of the in-court identification from the alleged victim of the offense is I believe that is the man. She points at Ed Johnson. The state's next witness is Will Hickson. If you'll recall, Will Hickson is the man who claimed the $375 for identifying Mr. Johnson. He repeated the same story that he told Sheriff Shipp, that he'd seen Mr. Johnson carrying a leather strap near the crime scene at the time of the attack. But this is how good Lewis Shepard really was, because on the limited amount of time that he had to prepare, and this is in the days before things like depositions, automatic discovery, things of that nature, Lewis Shepard was still able, under cross-examination, to establish that Mr. Hickson was actually nowhere near the scene of the crime nowhere near the scene of the crime on the night of the attack. In fact, rebuttal witnesses that were called by the defense testified that on the day the reward was announced, which the reward was announced 2 days later, the day the reward is announced in the newspaper, they saw Mr. Hickson walking by a church where Mr. Johnson was repairing a roof, because that's what he did during the days. He worked for churches. He worked as a carpenter. Mr. Hickson walks by the church, sees Mr. Johnson, casually finds out who that individual is, and within an hour of learning Ed Johnson's identity, he goes straight to the sheriff and says, "That's totally the man who I saw with a leather strap near the attack."
Wow.
It's very, very clear to anyone who's looking at this with a degree of impartiality that this is a complete setup. Ed Johnson's not the guy who's responsible for this attack. The trial, of course, unfortunately still continues, because that's just how stuff went back in those days. And I cannot stress enough how excellent of a job that Lewis Shepard did with regards to building the defense under incredibly complicated circumstances, because the defense called 17 witnesses in total in Ed Johnson's case, including the dozen witnesses who swore under oath that Ed Johnson had been at the Last Chance Saloon. Like I said, it's unclear from the record whether or not Sheriff Shipp bothered to look into that. Lewis Shepard absolutely did. And Lewis Shepard found those 12 people and he brought them to court, and they all testified that they saw him on the day of the attack. The trial itself lasted a total of 2 days. So deliberations start on February 8, 1906. And this is where things absolutely go off the rails. If you thought that stuff was crazy up to this point, it gets
Yeah.
worse. You
Yeah.
wouldn't even think that it's possible for this to get worse, but it gets worse. So,
Take us
what we
through it.
have, yeah, exactly. What we have in modern times these days, um, modern juries have the ability to ask questions of witnesses while they're testifying. They can ask questions of the witness to kind of get clarification for earlier testimony that's been provided, questions that maybe the defense attorneys didn't ask that the juries think are important. In this particular set of circumstances, the jury was allowed to act a little bit more akin to what we would refer to as a grand jury situation, where the jury is allowed to engage in a little bit more questioning. So during the deliberations, the jury asks that Nevada Taylor be recalled to the witness stand specifically for the purposes of answering questions from the jurors. So Nevada um, Taylor gets
Taylor.
recalled to the witness stand, and and we have this is all recorded fact. This is all these trial transcripts used to be taken down by hand. Stenographers would sit there, they would write the questions. You would hope that they were writing them correctly. Obviously, there's not really any recording equipment except for pen and paper. But according to the trial transcript, one of the jurors asks Nevada Taylor, Miss Taylor, can you state positively that this Negro is the one who assaulted you? Answer: I will not swear that he is the man, but I believe that he is the Negro who assaulted me. And again, remember, you know, 3 weeks ago, she doesn't know who attacked her. She can't make any identification, but because of the press, because of the media frenzy, because of basically the mass hysteria from the crowd, in her mind, she has been attacked by a black man. It's this black man. So another juror, and this isn't even a question from a juror. This is just someone in the jury box who stands up and screams, in God's name, Miss Taylor, tell us positively, is that the guilty Negro? And the answer to that question, raising her left hand towards heaven, Nevada Taylor replies, listen to me. I would not take the life of innocent man, but before God, I believe that this is the guilty Negro. So, she's making a big show out of it, and all hell breaks loose at this point in time. One of the jurors leaps out of the jury box and charges Ed Johnson. A juror tries to attack the defendant in court, in trial.
Wow. Oh my gosh.
It's insane. This is not how this is supposed to, excuse me, this is not how this is supposed to work.
Oh, this isn't how you're experiencing things in the greater Indianapolis days?
Absolutely not. We, with all due respect to our listeners in Tennessee, we are clearly a little bit more civilized, I guess, or at least we are in 2022 compared to how it was in 1909.
Holy
Um,
moly.
but yeah, the juror, like, and again, remember, you've got lots of credit to the court reporter, lots of credit to the stenographer, because the stenographer is still
Right.
taking down everything that's going on. That's how we know what's happening here. And the stenographer makes note that the juror who's trying to attack Ed Johnson apparently is shouting that if I could get at him, I would tear his heart out right here. So you have a juror who has now attempted to attack the defendant, who has threatened to kill the defendant right there in the courtroom. And guess what happens to this juror? He gets sent right back to the jury room to continue the deliberations.
Unbelievable. Unbelievable.
As I'm sure you can guess, this is again the worst kept surprise in the history of anything. Ed Johnson gets convicted of rape. Judge McReynolds informed the attorneys that he planned on sentencing Mr. Johnson to death. This is before any argument whatsoever. There has literally just been a conviction entered, and the judge tells the defense attorneys, I am going to sentence your client to death. Like, there's no arguments been made. Literally, the judge just says, like, yes,
Wow.
we're having a hanging.
Unreal.
So, they're meeting. Mr. Johnson meets with his attorneys. At this point in time, they're beaten down. I mean, they've had 10 days to prepare a trial.
Hmm.
Every attempt at
Long
getting more
days.
time, every attempt at getting cooperation, every attempt at moving it to somewhere where you might not, oh, I don't know, get attacked by a juror in the courtroom. All this stuff
Yeah.
is all this stuff has been shot down.
Hmm.
So, they meet with Mr. Johnson and they tell him that appealing the conviction would be a pointless waste of time. And that the judge has already announced that he's going to be sentenced to death. And he had two choices. He could basically die at the hands of the law, or he could die at the hands of a mob. Those were his two options that were presented to him by his attorneys.
Oh man.
That's what Mr. Johnson is facing. So the next day, on the afternoon of February 9, 1906, Ed Johnson stands before Judge McReynolds to receive his sentence. When he was asked if he had anything to say before the pronouncement of sentence, according to the court record, Mr. Johnson stood with his head high and said, "The jury says that I am guilty, and I guess that I will have to suffer for what somebody else has done. I guess I will be punished for another person's crime." And following that statement, Judge McReynolds sentenced Ed Johnson to be hanged from the neck until dead on March 13, 1906, in the basement of the Hamilton County Courthouse, Chattanooga, Tennessee. So that was the background, the identification, the trial, and the condemnation of Ed Johnson. Like I said, the guy who should be the central character in this, the central
Yeah. Yeah.
focus. This is everything that's
Absolutely.
happened to him at this point.
And less than a month earlier, he was, doing his job on a Friday night, at the bar or repairing roofs at the local church. I mean, this
Exactly.
he was a working man, and just had his life totally flipped upside down based on
Absolutely.
what seemed to be, the press stoking the fire and false presumptions running forward with it. So, Jack, the big conversation here, the idea of a forgotten legal landmark in our conversation in United States versus Ship, is the fact that this criminal case ends up in the Supreme Court.
Right.
I know we have a lot to get to with this conversation still. We had mentioned at the beginning for our audience that this could be a two-parter. I think we're leaning towards that a little bit. Why don't, as we kind of bring the conversation in the background of the conviction, the condemnation of Ed Johnson to a close, set us up for part two. Where does the Supreme Court step in, and how do we leave our audience with a little, maybe a glimmer of hope in what has been a pretty gruesome story to begin with.
Well, to kind of give everybody a preview for the next episode, which should finish the balance of the story, the next two people that we're going to meet are, again, two people that should be memorialized in the history of the legal profession. Noah Pardon and Styles Hutchins are going to be the next attorneys who come into this case. And what Mr. Pardon and Mr. Hutchins do is they figure out how to get this case into the federal court system using the Habeas Corpus Act of 1867. And a habeas corpus it's a petition that gets filed before a court. In this particular set of circumstances, it's specifically filed in the federal courts that argues that your incarceration is unconstitutional for one reason or another. There has been some sort of constitutional violation that has led to you being incarcerated, that has led to you being held. And as a result, you need to let me go. It's a civil proceeding. And this is where the precedential value of United States versus Ship comes in, because the arguments that Mr. Pardon and Mr. Hutchins were making, they were completely new arguments. The Habeas Corpus Act of 1867, no one knew what it did. It was
Hmm.
a statute that had never been litigated. There are an astounding number of statutes that get passed at both state and federal level that never get examined by courts because there's never a reason for them to get in front of the court. This is the first time the Habeas Corpus Act had ever been cited or argued in a courtroom. And the glimmer of hope that comes along with this is the Supreme Court accepted their arguments and temporarily halted the execution of Ed Johnson. And that's probably the hopeful part that we can look at for our next episode, is that the Supreme Court does step in. The Supreme Court does try to stop the execution that was ordered by the judge and by Judge McReynolds in Chattanooga. The rest of it we'll kind of go into in the next episode with what those procedures were, how that process went, and ultimately what led to this case being a criminal case filed directly to the Supreme Court. But yeah, the precedential value portion of it will come in part 2, and the explanation for how we got to where we are today with this as being a legal precedent.
Right. And I'm excited to jump into part 2 with you, Jack, especially given that, yes, this case, while it is a forgotten legal landmark, boy, are there some fireworks in it to begin with. And then, of course, I'm excited to peel back the curtain with you and dive into really the aftermath of all of this, what this means for not only trials similar to this as history continued onward, but also the Supreme Court's involvement maybe in criminal cases, and why maybe we don't see as many beyond that case moving forward. So a lot to unpack in part 2. Really hope anybody that joined us today live on the Facebook live stream, or if you are with us after the fact, please, be sure to tune into part 2. A lot of good stuff still remaining here in United States First Ship. But Jack, any final thoughts on this? Really the story, I guess we should say, really of Ed Johnson, the first part of this story. Any final thoughts? Anything you want to leave our audience with before we wrap up today?
Just again, it's tragic from start to finish. Yeah. What happened to Nevada Taylor was atrocious. It's horrible. What happened to Ed Johnson is in a lot of ways worse. I guess I don't know. I guess the thing that I would comment is the press has always been the bane of criminal defense trials. We talked about that a little bit with the Rittenhouse case and some of the other major ones. Anytime the media gets their teeth into a case, it becomes so incredibly hard to actually see that justice is properly carried out. And again, major credit to Louis Shepard for doing everything humanly possible to making sure that Ed Johnson did get as good of a defense as he did. It would have been way too easy to just allow the other two attorneys who had never handled a criminal case do this, but he's one of the unsung heroes in this for at least trying.
Absolutely. Well, look, Jack, really appreciate you and your time, carving some time out of the day to be with us, to walk us through this first part of United States First Ship. And hey, looking forward to having you back on the next one and getting into part 2 here soon.
Absolutely.
Alrighty, look, and hey, we want to take one final moment, of course, as always, to thank you, our audience, for jumping aboard with us on the Facebook live stream or on YouTube or a podcasting platform. All the same, we appreciate you being here for the conversation today. If you did like the show, do me a favor. Like it, comment, subscribe to it on whichever platform you're checking us out on. And then, of course, share this material with friends and family, anybody that you think would benefit from these criminal law related discussions that Jack and I have each episode here on Closing Arguments. We've got a lot of great stuff, including part 2 of United States First Ship, in the pipeline for you. We're looking forward to those conversations, and we would hate to have you miss out on anything great here in the near future. So for Mr. Jack Razumich, I'm Ryan Ruff. We're going to go ahead and say so long today, and we thank you so much for joining us on today's edition of Closing Arguments.